All right, money judgment summary. Here's where this might apply. If you filed a motion for child support and you said that the other parent owed back child support, you would then include the time periods, who owed child support, who is entitled to child support, and the amount. The interest would also come up if that's something you've asked for in the motion. The statutory rate of interest is 12% per year. In this case, we're going to assume that there is no money judgment and that nobody owes back child support. All right, so again, this is a temporary order. When you're filling out these orders, by the way, it is very important that you check every box, fill out every section. If it doesn't apply, you need to tell the court that it doesn't apply. All right, so we have Joe and Jane Smith. Joe will be the first parent. Jane will be the second parent. So now we need to go back to the worksheets that we completed to get the income information. So it's looking for the net income. That is found here in section 3. And each parent has the same net income. So we put that here, 4163. All right, so in this case, this was based on an actual pay stub. So it's the parent's actual income. It is not imputed. Now, if you do not know the other parent's income, then you can impute the income. Now, how you do that is, first of all, you look at historical income. If you don't know the historical income, then there's a couple other options. If it's someone who has recently graduated high school, has recently been incarcerated, or has never really held a full-time job, it might be appropriate to impute that person at minimum wage. Otherwise, what you could look at also is the median income tables. And I'm going to look for the child support instructions. Here we go. That's going to be on the standards and definitions and schedule. So this is WSCSS schedule. Because I don't recall off the top of my head what the different figures are. So for someone who might have some more education, maybe they have more of a work history, but you still don't know what they make, it might be appropriate to impute them based on the median income. Here we go. This is based on Washington State, and it's broken down by gender and age range. So in the case of Jane Smith, we said she was a 30-year-old female, so her median income, if we had to impute her, would be $28.16. But for this example, we have the pay stub, so we don't need to do that. All right, so in this case, neither parent has income from a second job. So we want to check the no box. And imputed income does not apply. It's important to let the court know who you're talking about, so you need to have the names up here as you're discussing that. Okay. So Child support can be affected by upper and lower limits. I don't often see that, but for very low income individuals or very high income individuals, there may be a reason to deviate from the child support. It does explain where the statutes are to find that. Now, no matter how low or high the incomes are, the worksheet calculator that's available here on the right-hand side will still give you a number and will still take into account that minimum, and well, it won't take in the maximum, but it will take in the minimum amount of self-support. There's a level at which the state deems that you need to keep for each parent's support of themselves, and so that could affect things. So you'll want to put each parent's name here and each parent's standard calculation from line 17. And that's on the right-hand side of the screen. Standard calculation for Joe here was 950. Standard calculation for Jane was 350. So that's what goes in this section. In this case, we are not getting a deviation. Now, here's the reasons for deviation here on page 5, and your situation has to fit into one of these different categories. Either you're asking for a lower amount because someone's supporting children in addition that are in other households, or perhaps someone has unusually high living expenses, or the children spend significant time with the parent paying support. These are all possible reasons for deviation. But deviations are discretionary to the court. So the court has to agree with you if there's a reason either to deviate lower or higher. The transfer amount then goes in section 10. In this case, remember, we were looking at Chloe Smith and we were saying she was 11. And so in this case, we're going to assume that Joe is paying support to Jane because Jane has Chloe the majority of the time. All right, so the start date, I usually start this the month after you're asking the court to sign these orders. So let's just say it's going to be July 1st, 2020. Now there's a couple of options. You can select either one payment. I usually see one payment by the 1st. The other common option is I see half by the 1st and half by the 15th. Sometimes people do it half by the 15th, half by the 30th. A step increase. Most of the time this doesn't apply. However, if the court's changing support and that's going to work a hardship, court can break down the increase. So that's what that is for. Periodic adjustment, I usually just check that first box that we're going based off of state law. However, the court can also set different standards to adjust support. Payment method. I always recommend that someone goes with the registry. The reason is because they track and garnish the amount of support. It makes it also easy to prove that if you're the paying parent that you've paid that. But you also have the option to say direct pay. That means the state will not collect, however, they can still enforce. That's what section 15 is about. You can delay enforcement. In other words, you can direct that the state not garnish. But you have to have a reason, and that could be that the other parent's been paying, that you're not asking the state to collect support. There's a variety of reasons that you can do that. The end date. For temporary order, you're going to want to check that first box. Otherwise, I typically check the second box that's until the child is 18. There are other reasons to extend that. For example, if you have a child who's unable to support themselves because of maybe a medical issue or a mental health issue. Post-secondary support, you usually want to reserve that unless the child is just about to graduate and college is a pressing issue. For tax issues, section 18, I usually alternate those between the parents. Medical support, you need to designate which parent is providing support. If you don't have information, you check this first box. Public health coverage is also an option. A lot of families will have that. And then If there is a premium, you would include that information. Otherwise, each parent is generally required to support the child up to 25% of whatever that number is here in line 17. If it's available, the parent is generally required to provide it. Section 20 is boilerplate law. It just says the same thing I already said, that you need to get or keep insurance that is no more than 25% of your basic support obligation. The court is required to say how uninsured medical expenses are provided. You'll notice here that if you're going to do something differently than what's on line 6, the proportional share, you have to explain why. You also have the option to talk about daycare, education expenses. That doesn't apply to every family. And then section 22 either allows the court to release someone from a past obligation or to set a judgment. And section 23 doesn't typically apply, but it's possible a parent was overpaying child support and the court can address that. All right, then at the end, the court signs it and there are some statutory warnings. All right, if you have any questions, I invite you to go to my website, TacomaLegalCoach.com, so I can explain that further. Thank you so much.